Thank you, Amelia, and thank you to everyone who is here, and welcome. Krupa and I both practice employment law in Morris Manning's employment group, and we are so glad you all can be here. Before we get started, Krupa and I first want to say on behalf of Morris Manning that we hope each of you is doing okay personally and professionally, and that if there is any way we can help in whatever way that may be, please know we are here for you. We hope that things are starting to look up a bit as well. On that note, as employers, as you're starting to think about bringing back your workforce, and maybe some of you already have been operating with some of your workforce on site, you're probably thinking about several different topics. And as employment attorneys, Krupa and I would like to walk you through some of the considerations at play as you think about bringing back your workforce. And I think it's important to note that the guidance at the state and federal levels is changing all the time, so please be aware of that. Today, we'll look at several different topics: the role of state and local orders in resuming business operations, a general framework to consider when returning your workforce, developing and communicating a return to work plan, handling any prior workforce modifications you may have made in March or April. What if your employees are concerned about contracting COVID on the worksite? And whether your employees have COVID, any screenings you can do. How to reduce the spread of coronavirus on your premises, and protecting against discrimination, harassment, and retaliation. We'll also answer some of your questions. And as Amelia mentioned, please type in any questions that you'd like to ask. You can do this during the presentation as well, and we can answer during the presentation if we're able. If we're not able to, we'll answer at the end. And then if we can't get to your question at the end of the presentation, we will try to reach out to you separately after the presentation. We'll also take a couple of informal polls of the group, which will allow you to see anonymously what your fellow employers are doing. So to kick us off, we wanted to ask how many of you are planning to return all of your employees in May, in June, later in the summer, or you're not sure yet. We will leave this poll open for a little while, for a couple of slides probably. And on the next slide, Krupa will discuss the importance of state and local orders when you're assessing whether to resume business operations.
So the first and most important question to answer is, can your workforce return to a physical office? To that end, it's extremely important to review applicable guidance from state and local entities to assess whether your company is permitted to reopen, so to speak. As a general matter, if your business was previously classified as essential or critical under applicable state or local guidance, you likely remain subject to those same operating guidelines. However, this is going to depend on the specific states and localities in which you operate. For other business entities, many states are implementing phased reopenings of certain industries and entities, and they're imposing specific restrictions for doing so. For example, in Colorado, the governor issued a safer at home order specifying that retail businesses could open with curbside service earlier this week. Retail shops will then be allowed to reopen their doors to customers on May 1st with strict precautions in place. On May 4th, commercial businesses can open with up to 50% of employees working in person. Critical and non-critical businesses and retailers with over 50 employees in one location should implement symptom screenings like temperature checks, and gatherings of 10 or more people are still not permitted in Colorado. Here in Georgia, effective last Friday, April 24th, gyms, fitness centers, bowling alleys, body art studios, estheticians, hair designers, and massage therapists were permitted to begin in-person minimum basic operations if they followed certain guidelines set forth by the governor. This includes, among other things, screening and evaluating workers who exhibit signs of illnesses, requiring hand washing or sanitation by workers at appropriate places within the business, providing personal protective equipment or PPE as available and appropriate to function, implementing teleworking for all possible workers, and implementing staggered work shifts where appropriate. Earlier this week, restaurants were also permitted to provide dine-in services subject to the limitations that I mentioned earlier and some other limitations as well. Finally, in Tennessee, per the Tennessee Pledge, restaurants and retail businesses are permitted to reopen at 50% capacity this week. The guidelines issued by the governor specify that reopening businesses should screen all employees daily. Additionally, high-touch surfaces are to be cleaned at least every 2 hours. And again, the pledge also states that employees should be allowed to work from home as much as possible. We conducted a flash poll with respect to employers with multi-jurisdictional workforces, and it looks like some of the attendees do in fact have employees in more than one jurisdiction. It's really important to remember that because company-wide or blanket return to work policies will not necessarily work for your particular workforces. Return to work guidelines and related employer obligations will vary depending on the specific jurisdictions in which you operate. And again, as Eleanor mentioned earlier, things are changing rapidly, so it's important to continue to review guidance and assess how it impacts your particular workforce. And we're seeing these, what we'll call controls, issued from state and local governments, but also on the federal level, and we'll be talking about these throughout the presentation. Eleanor, can you provide some more context here and discuss how these controls should impact an employer's return to work strategies?
Yes, thanks,
on the next
Krupa.
slide.
So many of the steps that Krupa discussed that state and local governments are taking are, of course, about requiring businesses to implement certain controls, so limiting the number of customers or requiring temperature checks. And we think it's helpful to think of all of these things in the framework that OSHA gives us for thinking about reducing the spread of an infectious disease at the work site. OSHA talks about this as a 5-part framework, and OSHA considers these 5 measures most effective to least effective. So the first is hazard elimination, and this is teleworking for all, and frankly, this is not going to be feasible for many of you all. It may be feasible, it may not be, it depends on what your business looks like. The next going down is personnel substitution, so that's, bringing in a skeleton crew for essential workers, and then everyone else who can stay at home stays at home. The next is engineering controls. Engineering controls are implementing a change to the environment, so removing, isolating, lessening, or redirecting the hazard. And we'll talk later on specifically about these final 3 bullets and how you might make these changes in your work site. The next are administrative controls, and this is a change to how employees do their jobs, safe work practices, training employees about hygiene and how to use personal protective equipment, staggering their shifts. And the last one is giving them personal protective equipment to use. And OSHA says this is useful when engineering controls and safe work practices cannot totally eliminate the hazard, but shouldn't be used as the only measure that you take. And we will look at the poll results on the next slide about how many of you are planning to return all of your employees in the upcoming months. All right, so it looks like 70% of you are unsure when you're planning on returning all of your employees to the work site. And then it's split, 10% has said May, 10% have said, 11% have said June, 10% have said later in the summer. So, many of you are making plans or you're not sure yet what you're going to do. When you are making plans, it's important to ensure that your plan complies with local, state, and federal orders or guidance. As Krupa was discussing, you must follow any mandates in local or state orders, and you must also follow any applicable federal orders or standards for your industry. For example, CDC has a no-sale order for the cruise industry, as I'm sure you've heard about. There are OSHA standards for the construction industry, for example. And then every employer must follow OSHA General Duty Clause 5A1, which says that every employer must provide a work site free from recognized hazards that are causing or are likely to cause death or serious physical harm. Now, to show compliance with the General Duty Clause, it's a very good idea to perform a hazard analysis. There are 3 components to this. First is to identify high-risk workers. You do this by looking at the jobs they perform. They may be high risk based on the jobs they perform, recent travel they've taken, or individual risk factors such as age or medical conditions. And I'm speaking specifically about COVID-19 in this case. The second is to identify potential exposure sources, looking at how workers are moving throughout the worksite during the day. Where are the places they're touching? Where are the places that this disease might be spreading? And then the third is identifying appropriate control measures. And those are the engineering controls, the administrative controls, and the PPE. How can you reduce the chances that your workers are going to be in contact with this virus? And then OSHA recommends fleshing out this hazard analysis into an infectious disease preparedness and response plan, or an IDPRP, which is a written multi-step analysis explaining what the risks are and how you plan to mitigate them. Now, on the next slide, Krupa is going to discuss business and industry-specific obligations, such as who returns to the office first.
So now that you have an idea about some of the overarching legal considerations to keep in mind when developing your return to work strategy, we want to discuss how your business or industry-specific considerations should come into play. If you decide to reopen any physical workspace, you'll need to determine who will return to the office first. Where possible, employers should consider transitioning managers or supervisors back to a physical office location first. But at a minimum, you should be consulting your managers and your supervisors regarding ongoing remote work capabilities and urgent and non-urgent business needs. Managers are likely going to be in a better position to understand the concerns and perspectives of your workforce, so it's important to consult them during this process. That being said, companies should be careful not to order certain employees back to work just because a supervisor prefers an office setting to a remote work arrangement. Instead, you'll want to assess employee productivity while working remotely and your urgent business needs to identify which employees to transition back to the workplace and when. Remember, state and local governments are still encouraging businesses to have employees continue to telework where possible. Given some of the unease around returning to a physical office space, employers may also want to consider instituting a voluntary callback program where they ask employees who do feel comfortable to return to the workplace. Once you have generally decided on the who, you should consider the how. For example, businesses should consider all available return to work options that work for your workforce. This might include, but is not necessarily limited to, staggered work shifts, modifying your in-office work week, and that could mean a gradual buildup up to 3, 4, 5 days in the office during a week, or permitting employees to work 3 or 4 days in the office and work remotely the remaining days of the week. As you're considering these various workforce options, we do want to remind you to keep potential wage and hour implications in mind. If job duties are changing because of reduced staff or new schedules, this may have an impact on any applicable overtime exemptions under the Fair Labor Standards Act or state wage and hour laws. So you want to be mindful of how modifications are affecting things moving forward. And all of your return to work policies, including the selection process on who returns to work first, should be implemented in a non-discriminatory fashion. It's important to balance fairness towards all employees with your company's legitimate business interests. With respect to communications about your return to work plan, companies should keep their legal obligations and business needs in mind. These communications should be clearly written and, at a minimum, reference applicable state or local guidance that permits return to a physical office, describes measures that you as a company are taking to protect employees, and designates a point of contact for questions about the transition back to the workplace. You should also make it clear to employees that plans may change depending on additional state and federal guidance, and that you'll update them accordingly. And on the next slide, we want to talk about how a particular employee's transition back to work is going to be impacted by how he or she was transitioned out of the office. Many of you are now wondering how any workforce modifications that you implemented in March and maybe earlier this month will impact how your workforce operates moving forward. For employers who conducted furloughs, the process of recalling employees can be somewhat straightforward. You want to notify employees to report to work and reactivate any sort of payroll processes for each returning employee that were previously paused. We generally recommend notifying employees of their return to work date at least a week in advance if possible, definitely further in advance if you can, but that'll provide you with a little bit of time to address any employee-specific issues that may arise after an employee is notified of his or her return to work date. Alternatively, if your company temporarily laid off any employees and there has been a separation in the employment relationship, there are other considerations as well. We still recommend providing at least a week's notice of a rehire date, and again, more where possible, but employers should also determine whether the employee needs to complete any new hire paperwork. So you should be thinking about what your typical new hire practices are and assess whether they might apply in the context of a rehire. For example, do you need to have employees complete a new Form I-9? For temporary layoffs, an employer can have an employee re-verify the I-9 or complete a new I-9 depending on the specific circumstances surrounding their separation and their original hire date. So generally, if an employee was temporarily laid off, but they completed their original I-9 more than 3 years prior to their rehire date, you're going to want them to complete a new Form I-9. This paperwork, new hire paperwork, could also include new restrictive covenant agreements, confidential or proprietary information agreements, and things along those lines as well. You'll also want to consider whether your company has any state-specific obligations related to rehire, and you should also review relevant customer contracts and industry-specific requirements to determine whether any additional rehire obligations exist. Examples might be whether you're required to rerun background checks. You want to keep in mind that before you rerun any sort of background checks for rehired employees, you need to have a valid authorization to do so. And if you do rerun a background check, you can't simply decide not to rehire someone based on any adverse information reported. You'll still need to provide the requisite notice in accordance with all applicable laws, including the Federal Fair Credit Reporting Act and any ban the box laws. Another important consideration is whether there are any policies that should be recirculated upon rehire or an employee's return to work. As part of your return to work planning, it's important for companies to assess their existing policies and ensure that they comply with their current business needs and applicable federal, state, and local laws, including all of these updates that we've just received. Leave policies immediately come to mind, but employers should also review compensation policies, timekeeping practices, and workplace safety policies that could be implicated as well. For those companies that implemented salary or hours reductions related to COVID-19, it's important to determine whether you intend to keep those reductions in place. And if you do, you want to communicate that to your employees clearly before you have them return to the office. Alternatively, if you're planning to implement these measures once your employees are back in a physical office location or as part of a phased return, you should determine whether any wage reductions have FLSA implications or are permitted under specific agreements governing terms of employment, so collective bargaining agreements, specific employment agreements, things like that. We did conduct another flash poll, so thank you guys for the audience participation. It's been really great so far. And it looks like 40% of you have implemented more than one of these workforce modification changes. A lot of you have implemented salary reductions. Yeah, so there's kind of a mixture across the board in terms of a workforce response. So a lot of these considerations that I just discussed are going to be relevant to your return to work policies And again, with all procedures that apply to your workforce, employers should ensure that any return to work protocols are implemented in a fair and non-discriminatory manner. And Eleanor, I'll hand it back to you for the next slide.
Thanks, Krupa. So if you have employees who are concerned about contracting COVID, this is bound to come up with your employees, perhaps especially so if you're not engaging in a voluntary callback of your employees, as Krupa discussed, is an option to consider when you're bringing back your employees. First, it's critical to engage in a two-way discussion. This gives you a chance to find out your employees' concerns and to ensure that COVID is the real reason. Keep in mind that employees may be entitled to reasonable accommodation for disabilities. It also gives you a chance to address potential workplace safety concerns and remind the employee that the company has hopefully implemented a robust safety plan. Note the potential for protected activity under the National Labor Relations Act. This is regardless of whether you have a unionized workforce. There's a potential for protected concerted activity if you have a group of employees or one employee on behalf of a group of employees who comes forward. If this happens, consult with counsel ASAP. And, as for whether an employee gets to keep working from home, that depends on the validity of the employee's concerns. This is, again, where a hazard analysis and perhaps a fleshed out IDPRP that we discussed earlier can come in very handy. And it depends on whether other employees are being allowed to telework. Flexibility is very desirable if that's feasible for your company. And keep in mind that precedent may be set for other employees with the decision that you make for this employee who is asking, to stay at home. And finally, consider a clear safety plan as a line of defense against health and safety complaints. Once again, this is where hazard analysis and IDPRP can be very handy, can be used to allay fears of employees who are afraid to return to work, and can be used as a defense against any health and safety complaints or litigation by an employee. In terms of an employer's potential exposure, we're getting a lot of questions about that, and we expect to see continued developments day by day here. First, some have asked about whether employers should require employees to sign waivers upon returning to work. That's a good thought. We don't think this would fly because it's not clear where employees would be picking up the virus, whether at the work site or somewhere else. But more importantly, this would be asking an employee to sign away a future risk, which would not be permissible. And as you may have seen in the news, some companies have been the target of wrongful death suits just during this past week. Workers' comp used to be the traditional route for this type of claim where someone was hurt on the job, but we're seeing seeing a shift from workers' comp to claims alleging that employers have failed to provide a clean work site, failed to provide PPE. Note this may or may not be necessary in your industry to provide PPE, failed to address the health concerns of employees with COVID symptoms. So what do you do about your employees when you think they may have COVID symptoms? And this is on the next slide where we will discuss this. And this is really important because it all ties in with what really is your duty as an employer to take steps to listen to an individual employee's concerns, as we just discussed, and to screen your whole body of employees, as we'll talk about now, as part of ideally that bigger safety plan you're enacting to take steps to reduce the possibility that this virus will spread further on your work site. Remember, we're not trying to get the possibility down to zero, and nobody is expecting that of you. That's not going to be possible. But it's about taking reasonable steps based on what you know about your work population and how they move about your work site. And let me pause here to say that, as you may have heard, there is a push in the Senate by Republicans for a broad liability shield against lawsuits by workers, so that your obligations to provide a safe environment likely wouldn't be zero, but they would be less stringent than the kinds of things we're talking about today. And as one of you asked about, as business owners, you'd probably be more successful pushing for no liability as long as you are providing some measure of safety, such as complying with federal and other applicable safety standards. It's not clear to us how this potential legislation will pan out, but what is clear is that, at least for the time being, it's absolutely recommended that you proceed as if this is just in the background and that you just wait and see what, if anything, comes of this. So in terms of screening options, you have options before your employees come back and then after they're back. So first, before your employees come back to the work site, you may test them to detect the presence of coronavirus. The EEOC has green-lighted this, but the EEOC has cautioned fairly strongly that employers must take steps to ensure the accuracy and reliability of these tests, given the possibility of false positives or false negatives. The EEOC has also noted that a negative test, as we know, doesn't mean the employee won't later acquire COVID, and urges employers to rely on infection control practices as much as possible. You may also take temperature checks, and you may do this of anyone entering your worksite: clients, vendors, customers, guests. You may require certification from a physician or self-certification that a person has had a clean COVID test, is not experiencing COVID-related symptoms, has not been in contact with a person diagnosed with or experiencing COVID symptoms. Note that normally, if we were not experiencing this pandemic, the ideal would be to get this from a physician, but EEOC has said you may need to permit doctor's office to give this to you on a form, the stamp, or an email. Given this pandemic, you may also need to allow self-certification, just given the logistics of things right now. You may ask an employee if the employee is experiencing COVID-related symptoms, has been diagnosed with COVID, or has been in contact with a person diagnosed with or experiencing COVID symptoms, and you may perform any other test sanctioned by the CDC or other public health authorities. Note that when you're asking about COVID-related symptoms, this is a broad symptom list. This is not the original couple of symptoms that we first heard about. EEOC has said you can ask about anything that we now know is a symptom of COVID or could be a symptom of COVID. And on the next slide, we'll talk about screening options for employees who are back at the worksite. It's pretty similar to what you could do before they come back to the worksite. You can test again for coronavirus. You can continue to take temperature checks daily, and then the similar list from before about requiring them to report if they're experiencing symptoms, asking them if they're experiencing symptoms, performing any other tests that may come up in the future. And note that no screening option is perfect. As you all may know from the news, tests may be inaccurate, it's too soon to evaluate, and the logistics of performing these tests may be just very impossible. Temperature checks may go false negatives. A lot of people with COVID don't have a temperature. And certifications, whether it's a self-certification or from a physician, or asking employees to report symptoms or contact reporting, this is going to be based on an employee's inaccurate statements, or could be based on an employee's inaccurate statements, and could rely on the employee's subjectivity. And now, an employer may be justified in refusing to let an employee enter the workplace if the employee is a confirmed COVID case, has a temperature, has other COVID symptoms, or refuses to answer the employer's permissible COVID-related questions. But note, you may wish to ask why in order to find out if the employee is afraid of disclosure of the information, so that you can assure the employee that you are going to keep the information confidential, as we'll talk about on the next slide. So whether you conduct screening before or after employees return, note that at a minimum, it's important to conduct some type of screening or seek certifications. Otherwise, this is a potential legal landmine. When we talked about OSHA's requirement to take exposure reducing measures, this is a big one. In the recent lawsuit I mentioned that we're seeing, lawsuits that we're seeing, there are allegations where employers are noticing that people have symptoms and are doing nothing about it. It is perfectly acceptable for you to go up to someone and say, hey, I'm noticing that you're having a persistent cough. Have you gotten that checked out? What you cannot do is go up to someone who is of advanced age and make an assumption about whether that person has COVID. But you can look at someone's symptoms and ask about what the person has done about COVID, or if the person has tested positive. And then it's important to view screening as an ongoing obligation, as we discussed a moment ago. It's not a one-time thing, it's an ongoing obligation, and this is for your protection against potential claims and keeping your workforce as safe as you can. And then it's important to follow applicable guidance, CDC, EOC, state and local guidance, and checking often for updates because it's changing all the time, and keeping all employee health information confidential in compliance with the ADA, state or local law, and/or applicable company policy. And keep in mind that if an employee is required to obtain a medical certification or test, state law may require you to reimburse that employee for costs and possibly compensate him or her for time spent obtaining the certification or test if the employee is non-exempt under the FLSA. And then apply screening uniformly unless there's an objective reason to single out that employee, like we discussed about seeing an employee with a persistent cough. And then develop and distribute a screening policy that reflects the above. Next slide, please. And there are some additional screening issues. So this is where things can get a little thorny. If you have an employee who was initially screened and didn't show signs of COVID, but later acquired COVID, it's important to think about what you're going to do. Are you going to quarantine the affected employee, shut down the office, deep clean the office, and engage in robust contact tracing, quarantine those additional group of workers? That's probably a good idea, but things to think through. And you may have paid leave obligations under the FFCRA. You may have them under new state or local jurisdictions that have enacted COVID-related leave laws. San Francisco is one, there are others. You may have potential paid leave obligations if your company decides to implement temporary COVID-related leave policies outside of FFCRA for retention purposes. Same goes with anyone who is experiencing COVID symptoms or may have come in contact with someone who's experiencing those COVID symptoms. So those people you've identified in your contact tracing efforts. If you send home an employee and that employee feels well enough to work from home, you'll need to compensate that person as if he or she is working at the office. And if that person does not feel well enough to work, note that the paid leave obligations we just discussed will be the same, but perhaps there's even more reason here to implement a temporary COVID-related paid leave policy to incentivize workers to stay home if they suspect they may have COVID or may have come in contact with someone with COVID. Because you may find that you have a lot of workers who have to go home because they were in contact with your employee zero. And on the next slide, we will discuss some possibilities for reducing the spread of coronavirus on your premises. So these are the three on the bottom of OSHA's list. We have environmental reconfiguration possibilities. This may include erecting physical barriers, especially important for those of you with open concept workspaces. You can place tape on the floor to show 6-foot separations, move desks so employees are facing away from each other, restrict the use of high-touch communal equipment, especially if employees can bring their own from home, like water fountains, soda machines, fridges. And of course, increasing housekeeping practices. And if you do that, you want to consult CDC and OSHA guidelines when doing so. And note that if employees will be performing housekeeping work, then there are specific CDC guidelines about that, including providing them with PPE and training them on proper PPE use. And as for administrative reconfiguration possibilities, there are many possibilities. A couple of them are to evaluate your high touch points and place single-use towelettes there, trash cans and sanitizer dispensers nearby. Remind employees frequently about touching their faces, washing their hands, and using hand sanitizer. This can go over email and this can go on posters, especially near those high touch areas. And considering staggering your work shift, as Krupa mentioned earlier, to the extent that's feasible for your business. And the last one, providing PPE to your employees. As I mentioned earlier, that this is viewed as a last resort when compared to the above possibilities, but it still can be useful and still should be considered. And note that it is required in some jurisdictions and in some industries. And on the next slide, Krupa is going to discuss discrimination and retaliation issues that may come up.
So regardless of whether your employees continue to work remotely or are going to be transitioned back to the office in the coming weeks or coming months, your obligations under federal, state, and local anti-discrimination, anti-harassment, and anti-retaliation laws remain the same. The Equal Employment Opportunity Commission, the EEOC, which for those of you who don't know is the federal agency responsible for enforcing laws prohibiting workplace harassment, discrimination, and retaliation, has reported an uptick in complaints regarding mistreatment and harassment of Asian Americans and other people of Asian descent in the workplace. This can be considered actionable and illegal harassment. There is also potential liability if certain at-risk populations, for example, older workers or pregnant workers, are completely excluded from a company's rehire considerations because of, concerns about the spread of COVID-19. As you ramp back up to more normal business operations in a physical office location, it's important to remind employees of or consider redistributing your equal employment opportunity policies and any anti-discrimination, anti-harassment, or anti-retaliation policies that you have in effect. Businesses should continue to encourage employees to report any incidents of discrimination or harassment that they experience or observe in the workplace pursuant to company policies. And you should also be reminding your supervisors and managers of their enhanced reporting obligations under the law. And this is also going to apply with respect to any harassment or discrimination from third parties, including vendors or customers. So you want to make sure your employees are reporting any sort of misconduct, harassment, discrimination that they feel that they're experiencing. And if and when you receive these complaints, you should promptly and thoroughly investigate and respond accordingly. With respect to health and safety concerns, employers should assess whether any complaints related to COVID-19 are subject to whistleblower protection under federal, state, or local law. You also may want to consider recirculating or implementing a health and safety or workplace safety policy as well. Some practical considerations for employers, as I mentioned earlier, continue to encourage employees to report health and safety concerns, report any concerns about discrimination, harassment, or retaliation, and ensure that your employees have avenues to immediately raise these concerns, particularly those related to health and safety. Employees should never be disciplined or terminated because they raised or escalated complaints about a potential violation of health and safety laws or procedures, including an employer's response to COVID-19. This also applies in the context of protected activity related to complaints of discrimination, harassment, or retaliation. Of course, there may be independent, non-retaliatory reasons for taking adverse action against an employee who previously engaged in this protected activity, but any decision regarding the adverse action should not take the protected activity into account, and you should consult legal counsel before moving forward with any sort of performance improvement plan or disciplinary action. As Eleanor mentioned earlier, Congress does appear to be prioritizing employer protection from COVID-related liability. However, as it stands now, any such protection wouldn't necessarily limit or otherwise protect employers from liability related to claims of discrimination, harassment, or retaliation. So companies are going to want to make sure that their current policies and procedures for addressing employee complaints about discrimination, harassment, or retaliation, this includes health and safety concerns, are complying with applicable law and can be changed to meet, the current realities of today. So for example, if you have an in-person reporting policy or employees are required to submit a hard copy of a complaint in written form, you may want to consider modifying your policy to permit electronic submission or, providing contact information for the designated individuals at your company if an employee needs to raise a concern. So with that, I will hand the reins back to Eleanor to take us into our Q&A session.
Thanks, Krupa. If you guys have it, we have a couple of questions that are open, and if anyone has any other questions, please feel free to type those and we can start going through those questions. So one question that's open is how do you request COVID-19 tests before an employee returns to work if they are not experiencing any COVID-19 symptoms, So it's best to request uniformly of all employees, or, before they get back to work, it's going to be hard to single out based on symptoms. You can single out based on symptoms as long as you have a reasonable belief based on objective evidence. So, that cough example, if you see someone with a persistent hacking cough, you can ask, have you been to a doctor? Do you know if you have COVID-19? But before the employees come back to work, you're not going to have that information probably. You cannot ask people who are of advanced age or people have medical conditions. You can't just ask those people about it. So it's best to ask everyone as opposed to singling people out before you have information about symptoms. And then someone has asked oh, go ahead, Krupa.
I was going to say, on handling common eating areas, that's going to, again, be a jurisdiction and industry-specific issue, but as a practical matter, limiting access to those areas, common eating areas, kind of break rooms like that, is probably going to be a best practice, at least initially. At a minimum, employers should be limiting the number of employees who can be in that area at a particular time in accordance with whatever the state or locality has mandated with respect to employee or regular gatherings. And you're also going to want to make sure that those particular common areas that are highly trafficked are cleaned appropriately and as necessary.
Someone has asked, with still so few tests out there or available, how feasible is it to require certification regarding COVID-19? That's a good question. So what a lot of employers are doing is they are asking employees to certify that they have not had a temperature, and or there are many things you can ask about. You can ask about some of these or all of these. You can ask them to certify that they are not currently experiencing COVID-related symptoms, that they don't currently have COVID or have not been diagnosed with COVID, that they have not been in contact with a person diagnosed with COVID, or have not been in contact with a person who is experiencing COVID symptoms. You want to make sure you're not asking about people only in the person's family. It needs to be broadly people they've been in contact with. As far as someone has asked, will physicians certify an employee if they don't have tests available? That sort of ties into the last question. They can certify based on what an employee is reporting to them about the employee's own symptoms and contact with other people or recent travel, and that's where it can be just very subjective and difficult, because that's why you might not have information about an employee's actual test history, which is what makes this in part a very difficult situation in bringing employees back to the workplace. In terms of who does the cleaning, someone has asked, is it staff? It can be staff. If it is staff, CDC guidelines need to be followed, and protective equipment needs to be provided, and training needs to be given on how to use that equipment. But a lot of people are hiring, special cleaners to clean the premises. If that's a possibility, that's great. If that fits with your budget. But you just be mindful, if you're having staff do it, again, you have more exposure there because, they're the ones cleaning.
With respect to the question about a standard questionnaire for all employees, similar to retail with customers, in the context of kind of having employees certify that they haven't experienced symptoms or haven't been exposed to somebody who's experiencing COVID symptoms, and kind of they haven't tested positive, things like that, you can use a standard questionnaire or self-certification for employees. You'll just want to be mindful of the responses that they're providing, and you may need to follow up for additional information based on the responses provided.
Someone has asked, what should employers do about public bathrooms, because these are often cramped and sanitization is left to building management companies. So any suggestions, she asks? Good question. You are certainly within your rights to close off areas of your building to the public, and this would be a really good time to consider doing that. That would be our suggestion on that one. Now, you may have to have, of course, depending on who's visiting, if it's certain clients or customers, you may have to, of course, have a bathroom or bathrooms available on a floor or floors for those visitors, but a very limited area would be acceptable.
Someone has asked, for those in an office setting that refuse to comply with safety precautions, so social distancing, et cetera, what actions would we recommend if a discussion with that person doesn't fix the issue? I mean, when you're implementing these workplace safety policies and providing guidance to employees, as with any other policy that's in effect, you can make it clear that employees who continue to violate these guidelines or these policies may be subject to disciplinary action. And I think also, you know, having just a real conversation where you're explaining their refusal to comply with these safety precautions could, you know, cause a spread of infection in the office place, and it's a real concern. But from a discipline perspective, you do have the ability to discipline employees for failing to comply with these safety protocols. Just going to want to make sure that everything is clearly outlined and that they're aware that they can be disciplined if they fail to comply.
In terms of how you perform temperature checks daily before employees enter the office and then send someone home who has a temperature without everyone knowing who it is, EOC has said that you have to do everything you can do to make sure that the employee's identity is not disclosed. But the EOC does acknowledge that, you know, if you're a smaller workplace, it just may happen that people can figure it out, right? But if you know, that doesn't mean that you don't keep those walls up and limit it to the people who would normally be in charge of confidential medical information under the ADA and your company policies.
And someone asked about the statement I made earlier about cleaning surfaces every 2 hours. That's in the context of Tennessee's Tennessee Pledge policy. It applies to restaurants and retail businesses. So the governor has issued industry-specific guidelines that mandate high-touch surfaces are cleaned every 2 hours as an infection control measure.
As for the question, someone has asked, can an employer automatically authorize individuals afflicted with pre-existing conditions that make them vulnerable to infection with COVID-19 to continue to work from home once the employer has requested that all other employees return to work? In other words, will that constitute discriminatory conduct in any way? So the employer cannot do that itself. But if an employee has a disability that puts him or her at a greater risk for a severe illness if he gets COVID-19 and therefore asks for a reasonable accommodation, this, you know, is a request for a reasonable accommodation. But note, you know, you may verify whether the employee has a disability and whether COVID-19 actually does put the employee at a higher risk, you know, of a severe illness if the employee contracts COVID-19. So you can't automatically authorize it. You know, you engage in that interactive process with the employee if the employee asks, or if you have reason to believe that the employee has made a request for a reasonable accommodation.
And just to piggyback up on that as well, you know, if you do have concerns about specific employees, I think engaging in a dialogue with them just about what, you know, their doctor recommends in terms of a return to work policy or a return to work protocol, it can be appropriate in this particular circumstance. but you want to be mindful of kind of not implementing a blanket policy with respect to those individuals and prohibiting them from returning to the workplace.
Someone has asked if our employees do not feel safe coming to the office, even though we try to provide a safe environment as much as we can we force them to work at the office? That's where it's going to be crucial that you can show what you've done to look at the hazards in your office and the steps you've taken to reduce those hazards. If you haven't taken those steps, then it's going to be hard for you to say to your employee that it is safe, or you're never going to be able to say that the risk is zero, right? But if you can show what you've done, that's going to be important. And if you've engaged in this really robust hazard analysis and maybe fleshed it out into that IDPRP, that's going to be really strong. It's going to be really hard for the employee to have a leg to stand on if you have to part ways with that employee. And if you're following all the guidelines in your industry, and not just OSHA, but CDC guidelines and all the federal and state and local recommendations and laws. There's a question here about if an employee has a high-risk child, can the employee stay home if other workers are required to return? Should the employer require a doctor's note on the child or do not ask? If I'm understanding this question correctly, it may be asking about the child's disability, in which case you should not ask. But if I'm understanding that incorrectly, then please feel free to type more, and then we can follow up on your question better.
Someone has asked whether employers can ask for self-reported temperatures and who would test the first person in the office. So you can request, you can ask employees to fill out certifications that require them to provide information about their recent health issues, if any. So you can ask them to designate whether they've had a fever of 100.4, which is, I think, what the CDC has identified as the appropriate fever temperature. You can ask them about whether they've experienced a fever in X amount of days, things like that. And you can have them certify that information. So you obviously want to get as much reliable information as possible, understanding that I think everybody has a thermometer at home. Sometimes that is a little wonky and doesn't work out very well, but you can ask for that information. And with respect to who would test the first person in the office, you are going to want to implement, if you're going to have a temperature check policy, you're going to want to implement any such policy in accordance with guidance from the CDC and from OSHA, and you're going to want to make sure you have somebody that's trained in the relevant procedures and can handle those temperature checks on site. So whether that's somebody on your staff already that has that capability or looking into outsourcing that function, those are available options.
Well, unfortunately, we are out of time. We want to thank you all again so much for attending. We hope it was useful. For those of you who have commented anonymously, we really hope that you reach out to us and we can follow up and answer your questions, because we are not able to get to everyone's questions. And for those of you who are not anonymous, we will reach out to you. Again, thank you so much, and we hope everybody stays well and take care.